So IP in 120 seconds. There are four main types of intellectual property: patents, trademarks, copyrights, and trade secrets. I'll go through just very high level on each of those. Patents, that's what we're really concerned about at Idea Clerk. Patents protect technical inventions, technical ideas. They're public by design and have a term of about 20 years. Public by design, what's that mean? So patents are published. They become public information, not initially, but eventually they are published and become publicly available. And the idea behind this, it's actually a constitutional right that we all have. Inventors are entitled to patents. It's a reaction to the guild system where information was held closely by insular groups. And that was viewed as hindering innovation. So the kind of the social contract with patents is that if you disclose your invention in an enabling way, so by enabling, that means in a way that enables one of ordinary skill in the art to make and use the invention without undue experimentation. So in the case of a startup, that might be an engineer, a competent engineer. If you could kind of give them enough information that they could replicate what you're doing without, having to work on it for 3 years, that would be a sufficient disclosure. So if you make that enabling disclosure, then the society gives you a limited monopoly on that invention. So it gives you kind of a head start, since as a reward for your creativity in inventing it and sharing that idea with the public. So in the U.S., that term is 20 years from filing. It says roughly 20 years because that time frame can be adjusted a little bit if there are delays by the patent office, but it works out typically to be roughly 20 years. Trademarks are for brand protection, so they exist to kind of avoid consumer confusion in the marketplace. So if somebody comes to ideaclerk.com, sees our logo, they know that they're working with us. It's not going to be somebody else. So for startups, startups will typically file on things like their name, their logo, slogan, things like that help identify the company. Trademarks are renewable, so as long as you're continuing to use the trademark, you can keep that trademark protection alive. Trademark rights are inherent. Just by using the mark, you get trademark rights. However, there are some very strong advantages to registering your trademark. Namely the presumption of validity. So if you're the first one to file your trademark, then anybody who challenges that, the burden is on them to prove that you're not entitled to that trademark right. So it's typically advised to at least get your company name registered as soon as you can. Copyright protection is also inherent. So if you, for example, draw a picture on a napkin, you have a copyright to that picture, whatever you drew. Once a creative expression is fixed in a tangible medium, so that tangible medium could be a piece of paper, it could also be a computer hard drive, just fixed in some way, the copyright is created. But like trademarks, there are advantages to registering your trademark, particularly if you're going to sue somebody for copyright infringement. Trade secrets are it's essentially information that has value because it's a secret. It could be back-end technology that nobody can see unless they're a part of the company. It could be business information, really any type of information that can be kept secret and provides a business advantage, can qualify for trade secrets. In order to take advantage of trade secret protection, there are documentation and procedural requirements. That's something an IP attorney could work out with you in your company. Typically for early stage startup, what you'll see is trademark filing, get your name on file, and start covering your technology with patents. Um, when it comes to patents, a strategy that a lot of folks will use is to file provisional patent applications. So a provisional patent application is essentially a placeholder. It gives you a priority date, it gives you a serial number, and it gives you the right to pursue patent rights on whatever you disclosed. Provisional patents from the date of filing, that starts a clock of 12 months before you need to convert it to a non-provisional patent application. That is what is actually examined and what can mature into a patent, an issued patent. But there are costs associated with that process. It typically works out to be a negotiation with the patent office. You file a patent application claiming a certain invention, and the patent office will come back and say, there's this prior art that's similar. You need to amend or adjust what you're claiming to be your invention. And there's money and time typically involved in that. So by filing a provisional patent application, you preserve the rights, but you delay the costs associated with prosecution. Filing early also gives you options. A provisional patent application never sees the day of light. If it is not converted into a non-provisional patent application, it will just go away. No one will ever see it. It will remain secret. So if you file a provisional application on something that you think you might want to have a trade secret, or you think you might want to have a patent, you don't have to make that decision for 12 months. So but provisional patent applications also kind of preserve maximum optionality in terms of your going forward IP strategy. So I talked about this a little bit on the last slide, the startup clock, why speed to patent pending matters. One big reason is just the speed of innovation today. So, startups kind of always move fast, sort of as a rule, but with the kind of emergence of AI-assisted innovation, it is just going much, much, much faster. You're moving faster, your competitors are moving faster, and so there's a great incentive to file early on your inventions. If you file before your competitor, your rights preempt your competitor's rights. So that filing date really, really matters. By filing a provisional, you lock in the priority, you lock in the rights to eventual patents. So it's a great idea to do that before you pitch, before you demo, before you ship. It also signals defensibility to your investors and enterprise buyers. They see patent pending on your website or on your marketing materials, and it essentially puts them on notice that you have filed patents on this stuff, and they should think twice before they before they think about copying it. Sort of a rule of thumb: if you've already pitched, if you've already shipped, if your technology has become public in any way, that very first disclosure, public disclosure, so kind of letting your technology be known to a third party without a confidentiality agreement in place, that earliest disclosure date starts a 12-month clock before you have to file some type of patent application. You can file a provisional, you can file a non-provisional, but if you do not file within that 12-month period, then whatever you disclosed is dedicated to the public. It can no longer be patented, and you have just missed out on potentially capturing great value for your company.